2. Calling the matter of the people of the state of Michigan versus Connor v. Wichert, 22-6806. Members of the jury have returned into the courtroom. Members of the jury, the court did not forget about you. There is a process. We have to prepare jury instructions, and the court is responsible for that. So that's what took up the time. And I'm my own law clerk. So the instructions that will be eventually provided to you, you can see there's some instructions here that you'll have to consider, but that takes a little bit of time. We try to make it as short as possible for any delays, but I'll take responsibility for preparing these instructions. But you're back here, and we are ready to proceed. The proofs have been entered in this case, and now it is time for closing arguments. Bahani, you may proceed.
Thank you, Your Honor. Ladies and gentlemen, I'll end the day the same way that I started the day, by thanking you for your attention today. I know a lot of times when you're here and you're having to sit still and you're having to listen to other people talk, it can get monotonous at times. And I really appreciate the fact that all of you have given your undivided attention to this case. Because as I pointed out to you at the beginning of the day, you are the finders of fact. You have to decide what happened on that particular day back in February of 22 in the city of Bad Axe. You've heard from the witnesses now. And let's just kind of recap about how we started off the day. You heard from Officer Gusa, and she testified that she had to respond to a call of an assault at McLaren Thumb region. And she went out there and she found Mr. Lasowski in the emergency department. And he was not cooperative. And he even testified to that effect. But he said he wasn't giving her any information. He did let her take pictures, and you saw those pictures, graphic pictures of the aftermath of an assault that had taken place earlier that day in the early morning hours. Officer Guza turned over her investigation to Detective Sergeant Knobloch, who continued by interviewing witnesses. He interviewed Morgan Weisenbaugh. He testified. He interviewed Nathan Lasowski again. He testified. He retrieved medical records from the hospital. And then before he testified, you got to hear from Dr. Remley from McLaren Thumb region, emergency room physician, somebody who is well-versed in all manner of medical and traumatic emergencies. And he testified that Mr. Lasowski showed up, told him that he'd been assaulted with some sort of metal or ceramic object. And Dr. Remley testified that the injuries that he saw and treated were consistent with that kind of assault. He testified that they were serious injuries, that he had to put the scalp lacerations back together with staples, that he was concerned about internal injuries. You heard the doctor say that when he first came in, he thought maybe it was just the nose, but then he treated it as a full trauma activation and performed radiology from head to abdomen to make sure that there were no other injuries, because he was concerned after seeing the extent of the injuries. You heard from Detective Sergeant Knobloch. He testified that after interviewing the individuals involved, that he went and saw a search warrant for Mr. Wichert's house. He went out to execute that search warrant at Mr. Wichert's house, and he found the item that he was looking for. In fact, he testified that Mr. Wichert, once Detective Sergeant Knobloch told him what he was looking for, Mr. Wichert walked right into the house, picked it up, and gave it to him. This thing, this metal bat. Detective Sergeant Knobloch continued his investigation and determined that, based upon his interviews with these individuals, that they were credible. And what had happened that night was that Connor Wichert assaulted Nathan Lasowski with this object, hitting over and over and over again. You heard from Morgan Weisenbaugh, and this is where it's very important for you to remember the questions that I ask you and the instructions that the court will give you about judging the credibility of witnesses. With Ms. Weisenbaugh and Mr. Lasowski too, it seemed pretty clear that they didn't want to be here. It seemed pretty clear that they don't have a 100% clear recollection of what took place that night. Not every detail, because admittedly, both of those witnesses said they'd been drinking all night with the defendant. The memory was a little bit hazy as to certain particular minute details. But the story that Ms. Weisenbaugh tells and the story that Mr. Lasowski tells are consistent. There's some sort of altercation between Nathan Lasowski and Connor Wichert. Mr. Lasowski says it's a wrestling match. Mr. Wichert says it's a fight. Mr. Lasowski says he tapped out. He was done. He lost. He testified that he quit. And then he testified that the next thing he knew, he was getting hit over the head with this. And he was continuing to get hit with this. Now, his memory may be a little fuzzy, but he definitely knows what happened up to the point where this thing hit him in the head. And Ms. Weisenbaugh, she knew what happened. She was watching it happen. So there's no question for you to determine, ladies and gentlemen, as to whether Connor Wichert used this weapon against Nathan Lasowski, because he admitted that he did when he was on the stand. He says he hit him with this thing. He says he assaulted him with this thing, but he said it was in self-defense. That's what you have to determine today, because the elements that we talked about earlier that I had to prove that Mr. Wichert made an assault, he did that. That he had the ability to cause great bodily harm, or at least he thought that he did. I think we can agree that that happened. And that injuries did take place. We saw the injuries. So the last element that you have to think about, because those three are done, the last one you have to think about is the self-defense element. That's why you're the finders of fact, and that's why your job is hard. Because you've heard testimony from Mr. Lasowski, who said, this was a wrestling match. It's what guys do. You drink, have a few beers, and you start messing around, and that's just what it was. And he tapped out, he quit. And then all of a sudden, Mr. Wichert leaves and comes back with this thing. That's not self-defense, ladies and gentlemen. A wrestling match, even if it was a fist fight that they were involved in, even though no one's testified to that effect, Ms. Weisenbaugh testified that it looked like a wrestling match to her too. But you don't get to use this to defend yourself against somebody who has nothing. Somebody who's just got a pair of hands. Somebody who thinks they're in the middle of a play wrestling match and instead gets wailed on by one of these. That's not self-defense. Mr. Wichert testified that he was in fear for his personal safety. And he was worried because he had had this accident several months prior. And he was concerned that if he was in any kind of fight, that it would make those injuries worse. So you heard him testify that after he put down Mr. Lasowski and pinned him to the ground and Mr. Lasowski quit, he went back to his bedroom. Oh, you're that afraid for your personal safety. It just seems logical that you might call the police at that point. But he didn't. He picked this thing up and he came back and he re-engaged with Mr. Lasowski. He hit him in the head with this thing, and then he continued to hit him over and over and over again. Where does the self-defense stop? When Mr. Lasowski's dead on the floor? Then you don't have to defend yourself anymore with this thing? It doesn't make sense, ladies and gentlemen. This is why you have to judge the credibility of the witnesses that you heard today. I know there's some gaps in memory, and I know that the witnesses that the people put forward don't remember every detail, but I want you to think about Mr. Wichert's testimony. He agreed that he'd been drinking that night, and yet his recollection of this evening seems to be absolutely 100% crystal clear. He has all of the details. Well, that's very convenient. Hey, but testified he was drinking along with everybody else. It's hard to imagine that he has such perfect, crystal clear, total recall of the events of this night. He says he got slammed into a table and put into the floor. Nobody else saw that. Mr. Lasowski didn't. Ms. Weisenbaugh didn't. He agrees that Mr. Lasowski tapped out, was done, was sitting on the floor making weird noises, he said. And that's when he went to his room and got this. Instead of getting his phone and maybe calling 911 and saying, hey, Bad XPD, could you come help me out? There's this guy who's in my house going crazy. Can you come get him out? No, he decided he was going to take the law into his own hands. And that's not self-defense. That is great bodily harm, less than murder. Ladies and gentlemen, at the end of the day, you have to decide and test the credibility of that argument of self-defense. And I know that after you have the opportunity to deliberate, you will find Mr. Wichert guilty of assault with the intent to do great bodily harm, less than murder.
Sorry. Best way that I can kind of explain that is I have ref basketball for 13 years until Gary was born. Gary was born, I gave that up. But I refed low-level college. I refed a lot of high school balls from Lansing to Detroit to Saginaw to a lot of the big schools. And there is one play that no matter what you call you make, just makes the gym go nuts. Players dribbling down the ball, going to the basket. Defenders slides in, last second, hands up, hit each other, roll to the floor. Half that gym's gonna stand up and they're gonna scream, "That's a charge, ref!" Half the gym's gonna scream, "Ref, it's obvious, that was a block!" And you gotta decide in that split second what your call is. Obviously, you have contact and 2 on the ground. Now, we weren't there that night. I wasn't there, you weren't there, Sergeant Knobloch, officers weren't there. The people that were there was Connor, Morgan, and Nate. So you have to look back and what do the facts tell us about what happened that night. Look at Nate's testimony. Nate says, we were drinking and then we just got in a wrestling match because that's what guys do. I don't think I have ever gotten a wrestling match with any of my buddies when we've been drinking, just because that's what guys do. He also says that Connor wasn't part of that group for a long time. I haven't seen him in a while, so how's Connor supposed to know that's what those guys do when he grabs him? And Morgan, bless her heart, she obviously is caught in the middle of 2 friends. It's clear to me that I think she knows more than what she wants to say. And she even says that there is argument coming from the kitchen. It doesn't sound like, hey, let's wrestle. Let's see who's stronger. Let's see who would win. Let's see what happens if if we lock up and see what goes down. No, she says there's an argument going. And then she hears to the point where there's commotion, which Connor tells you is when he got slammed through the kitchen table. Now, the first incident, and we see the map, happens there in the kitchen, in the dining room area right there. Morgan was on the couch. It had to have been loud enough that she actually heard it, because she hears the commotion, she hears the argument, and she's it happened here. And Nate says, after he's on the ground, he is able to get up and he sits with his back up against the wall. And he sat against the wall while the whole altercation happened with the bat. You saw the pictures. If I'm sitting here like this, how are any of those welts happening to my back? Even one. Am I going through the wall to hit him? It doesn't make sense. What makes more sense is what Morgan told you. That after they broke up that first fight stops, Connor walks down the hall. And the government loves to say, well, he could have called 911, he could have called the police. But he tells you that he's going to get his friend Josh, as another adult male in the house. He's going to wake him up to get help. And this isn't a mansion. We're not talking about some Beverly Hills palace. This is a little two-story home. It's not that far of a walk. And before he can even get into the bedroom, that's when he hears, I'm gonna fucking kill you. So what does he do? He grabs the bat. And if you ask, when you deliberate, this can go back, you'll see this is a very solid piece of metal. This can do some damage. And he stands there with it. And despite seeing this, Nate still charges him. Connor uses the bat only to defend himself. If he was intent on committing great bodily harm, there is not a single broken bone for Nathan's back. All he has, he's got some good welts and he's got some good bruising. But if you wanted to break a bone with this thing, you can easily break a bone with this thing. And that didn't happen. That tells me that he used this only as necessary to defend himself. And Nathan kept coming at him, kept grabbing his legs, kept trying to pull him down. And the second he stopped with the bat. At any point, Nathan could have called 911. When he went into the bathroom, he could have called 911 and said, hey, I just got assaulted. The government tries to shift that burden over to Connor and say, well, why didn't Connor call? Well, why didn't Nate call? If he was just sitting there in the hallway up against the wall while he was getting beaten, when he was taken into the bathroom to be cleaned up, why did he call 911? Or on the car ride home, why did he call 911? Or while he's laying in bed, why didn't he call 911? Deputies are dispatched to the hospital by the hospital because of the assault complaint. He doesn't call 911 because he knows he started that fight. He kept coming after Connor and he knows he's responsible. I'd argue to you that's why he doesn't say in the beginning who did it, because he doesn't want to get in trouble for it. As Morgan even told you, Nate would have kept coming at Connor if Connor hadn't used the bat. Friends with both of them, and that was her opinion. That he had no other option but to use that bat because Nate was going to keep coming at him. Prosecutor says, very convenient that Mr. Wichert has such a good memory over this and none of his witnesses do. You got to remember, they were at the bar drinking. Nate said he had 7 to 9 beers before Connor got there, who came straight from work. And then he had a couple of beers, he said he had the 4 in a couple hours when he was at the house. Assuming Nate had the same amount, and that puts him 13, 14 beers. And you heard the doctor's testimony. At 2 p.m., he was a 0.098, so just below 0.01. And an average person is going to purge that alcohol 0.02 an hour. There was no testimony that he went home and started drinking or went home and took a couple of shots to numb the pain or something along those lines. He said he went home and he went to sleep. He woke up, he saw the blood and went to the hospital. So there wasn't any extra alcohol to up those numbers. So do the math in your head. At 3:30 to 2 p.m., you're talking 11 hours. That's an extra 0.22. That means he was probably over a 0.3 at the time of the incident. Almost 4 times the legal limit had he been driving a car. Prosecutor says that Morgan and Nate testify consistently, but Morgan's argument or testimony was that there was an argument in the kitchen. Nate says there wasn't, it was just a friendly wrestling match. Morgan says Connor leaves the room and Nate follows after him. That's not what Nate says. Nate says he sat up against that wall the whole time the assault took place. So look at whose testimony is the most consistent. You'll get a copy of these jury instructions. And when you go back there, you'll get a chance to read them, and judge will read them to you. And if judge says something different than me, judge is right and I'm wrong. But you're gonna be told that a person never has a duty to retreat when they're in their own home. Honor is in his own home. He does not have to retreat from the fight. He doesn't have to go somewhere and call 911. But he does. He tries to go get Josh. He tries to go get Josh. Hey, you gotta help me get him out of here. Never gets that chance because he hears, I'm gonna fucking kill you. And that's when he grabs the bat to defend himself. When you look at self-defense, you first have to decide whether the defendant must have honestly and reasonably believed that he had to use force to protect himself from the imminent unlawful use of force by another. He'd already been wrestled down in the kitchen. He hears the, I'm gonna fucking kill you, and now he sees Nate charging him. Reasonable to believe he's got to use force. Second, that a person is only justified in using the degree of force that seems necessary at the time to protect himself. He already tried once to defend himself with his hands. That was unsuccessful. Despite that, Nate is coming at him a second time. And as we heard from the testimony, he actually comes at him a third time. Even after the incident with the bat, Morgan tells you after he gets out of the bathroom, he tries to attack Connor again. He's that intent on assaulting Connor that even after everything that happens with that bat, he still wants more. That's why it was reasonable to use the bat. And third, the right to defend one only lasts as long as necessary for the purpose of protection. Government makes this huge argument. Oh, what's he gonna do? Beat him to death and then he doesn't have to use it anymore? That's not what happened here. The second Nate stopped coming at him, he put the bat down. The bat stayed in the living room. Officer showed up a couple of days later. Yeah, I know exactly what happened. Here you go. Here's the bat. He turns it over. He didn't have anything to hide. So the government has to show every single one of those elements. When they're making their pumpkin roll, they have to have the flour, the sugar. They have to show the intent. I argue there was no intent to hurt him, to commit great bodily harm less than murder. The intent was merely to stop the attack. They have to show that he did not act in self-defense. I think he clearly acted in self-defense. So when you go back there and you start talking about the case, and you start to think, well, was this self-defense or not? If you think maybe it was self-defense, that's not guilty. If you think it was probably self-defense, that's not guilty. You have to decide beyond a reasonable doubt that Connor did not act in self-defense. If you can't decide that beyond a reasonable doubt, you have one verdict, and only one verdict you can make, and that's not guilty. Now, because the government has the burden, they're gonna get one last chance to talk to you. This is the last time that I get to speak with you. But just know, obviously, anything that they say, I would have a rebuttal to. I'll be on my hands over there, trying not to jump up and down. But on behalf of myself, on behalf of Nick, on behalf of Connor, we want to thank you for your time and thank you for listening today. Thank you.
Thank you. Rebuttal.
Thank you.
You're welcome.
May I have the screen?
Yes.
So, ladies and gentlemen, I do have the burden of proof in this case, so that's why I'm talking to you again here. And I just want to ask you to rely on common sense. What makes sense about what happened that night? Does it make sense that Mr. Wichert testifies that there's no time to call 911, but there's time to run into his bedroom? And there's time to wake up this person, Josh, to try and get help from him. But there's no time to call 911. Even though he's in fear for his life or for his personal safety, no time. Time to run down the hall, grab this. But no time to pick up a phone and dial 3 numbers. in the city of Bad Axe, police are usually about a minute away from you if you call. He's worried about time. He testified that he ultimately went and retreated and hid in the basement because he was so frightened for his personal safety, yet didn't call 911. His whole argument for this self-defense idea is that he was concerned for his personal safety and he had to use this bat in order to protect himself, but that doesn't make sense. Ladies and gentlemen, let's just look at people's 1 through 9 here. Okay. So this laceration on the scalp, Mr. Lasowski believes that the first place he got hit was his head. That's what he thought. His memory is definitely a little shaky. After getting hit in the head, perhaps yours would be too. Maybe that's self-defense. But ladies and gentlemen, it just kept going. The face. And Mr. Garski pointed out there's no fractures in his back, no broken bones, only broken bones in his face instead. No broken bones in his back, just his face, so that's okay. Another laceration, more bruising. But ladies and gentlemen, these are the ones that are telling. Self-defense. Why are all these marks on Mr. Lasowski's back? Like he's trying to get away. You're defending yourself against somebody who's charging you. Is he suggesting that Mr. Lasowski charged him backwards? And that's where all of these marks across his back came? That doesn't make sense. These marks that match up with this, that doesn't make sense. When does this self-defense end? After the first hit, after the second one, third, fourth? Well, he's just done on the ground. Common sense, ladies and gentlemen, tells you that this wasn't self-defense. Mr. Wichert was aiming to put Mr. Lasowski down, or else he would have just called for help and gotten the police to haul him out of there. And that's why you're going to find him guilty today. And I thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will instruct you on the law. That is, I will explain the law that applies to this case. Remember that you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are, and this is your job and it's no one else's. You must think about all the evidence and decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. And if the lawyer says something different about the law, please follow what I say. At various times, I've already given you some instructions about the law, and you must take all of those instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. So to sum it up, it is your job to decide what the facts of the case are, to apply the laws that give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you decide the case, that is, discuss the case, decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to think or to understand that is what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into the evidence, and anything else I tell you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe to you some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered and may have stricken testimony heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based upon all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based on only the evidence admitted during this trial. Now, facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you were to look outside and see rain falling, that's direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you saw a person coming in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or combination of circumstantial evidence and direct evidence can be used to prove elements of a crime. In other words, you should consider all the evidence that you believe. And as I said before, it is your job to decide the facts of the case. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, suggestions, threats, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you should accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of a statement it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. You may consider whether the defendant has a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. As you are aware, the defendant is charged with the crime of assault with intent to do great bodily harm, less than murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed that he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary. But if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. The intent with which an assault is made can sometimes be determined by whether a dangerous weapon was used. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about February 26, 2022, in the city of Bad Axe, County of Huron, County of Huron, State of Michigan. A person is never required to retreat under some circumstances. He does not need to retreat if attacked in his own home or is subjected to a sudden, fierce, and violent attack. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. As you're aware, the defendant claims that he acted in lawful self-defense. A person has the right to use force to defend himself under certain circumstances. If a person acts in lawful self-defense, his actions are justified, and he is not guilty of assault with intent to do great bodily harm, less than murder. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. First, when he acted, the defendant must have honestly and reasonably believed that he had to use force to protect himself from the imminent unlawful use of force by another. If belief was honest and reasonable, he could act at once to defend himself, even if it turns out later that he was wrong about how much danger he was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect himself from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as he saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting himself, but you may also consider how the excitement of the moment affected the choices or the choice the defendant made. Third, the right to defend oneself only lasts as long as seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent him from claiming self-defense if he was attacked. There's been evidence that the complainant may have had a reputation for violence. You may consider this evidence when you decide whether it was likely that the complainant threatened to hurt the defendant physically and whether the defendant honestly and reasonably feared for his safety. When you go to the jury room, you will be provided a written copy of these final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual and considered judgment of each juror. It is your duty, that is, as jurors, to talk to each other and make every reasonable effort to reach agreement. Express your opinion and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your difference. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own. You must vote honestly and in good conscience. If you have any questions about these instructions before you begin deliberations or questions about the instructions that arise during deliberations, just simply knock on the door in the jury when you're in the jury room and submit a note to the bank. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you wish to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. At this point, it is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, not even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal that to anyone outside the jury room. When you go to the jury room, as I stated, you will be given a copy of these instructions you have just heard. As you